Hello and welcome to TaxPundit. The case under discussion is Directorate General of Goods and Services Tax Intelligence HQ versus Gameskraft Technologies Private Limited and ORS, court name, pronounced on date. The dispute began when the Directorate General of GST Intelligence issued show cause notices under Section 74(1) of the CGST Act, accusing Gameskraft Technologies and others of deliberately evading GST by classifying betting activities as services. The Karnataka High Court quashed these notices, ruling that such activities were not taxable as actionable claims. Meanwhile, other cases involving fantasy sports platforms like Dream 11 were pending. The Supreme Court took up all matters together to settle the law. The Supreme Court first examined what constitutes betting and gambling under Indian law. It held that while the distinction between skill and chance games persists, when these activities are commercialized on digital platforms where participants pay to get a chance to win prizes, they become actionable claims. This characterization is crucial for GST applicability. The court analyzed the GST framework and concluded that the supply of actionable claims like the right to join a betting pool or gaming contest determined by chance qualifies as a taxable supply of services. It dismissed the idea that these transactions are just software services. The real supply is the chance to win money from the wagering pool. The Supreme Court upheld the constitutional validity of the GST levy on betting and gambling. It found no violation of fundamental rights because the classification based on the element of chance is reasonable and connected to the objective of taxing speculation. Additionally, both Parliament and state legislatures, through the GST Council, have the power to impose such a tax under Article 246A. A significant part of the judgment deals with Rule 31A of the CGST rules. The court ruled that this rule, which sets the valuation method for online gaming and casino supplies, is valid under Section 15 of the CGST Act. It was needed because the consideration is not just the platform fee but the entire amount wagered. The court also clarified that Rule 31 covers all betting and gambling, not just horse racing, and that the GST Council's recommendations give it legislative support. Regarding the 2023 amendment, the Supreme Court stated that it operates prospectively. However, the court's own interpretation in this judgment clarifies that the levy on such supplies always existed under the original GST framework. So for prior periods, the tax remains applicable as per this ruling. On valuation, the court made it clear that the tax base is the entire consideration paid by participants, such as the entry fee or bet amount, not just the platform fee or service charges. This is because the entire sum is the price for the actionable claim, the chance to win. The so-called commission approach was rejected as it mischaracterizes the supply. In conclusion, the Supreme Court's judgment is a strong endorsement of the government's position. It confirms that these activities are taxable as actionable claims, upholds the valuation rule, and clarifies that the law applies from the start of GST. This decision will significantly impact ongoing tax disputes and future enforcement. Let's answer some frequently asked questions. First, the core issue. The Supreme Court decided that online gaming, casinos, and betting activities are taxable supplies of actionable claims under GST. Next, regarding Rule 31A, the court upheld its validity, confirming it fits within the statutory framework and provides the correct valuation method. On the 2023 amendment, the court said it is prospective, but the pre-amendment position already subjected these supplies to tax, as clarified by this judgment. Yes, fantasy sports like Dream 11 are covered. Even though they involve skill, the commercial wagering structure makes them fall under betting and gambling for GST. The tax is measured on the full entry fee or bet amount, not just the platform fee, because that entire sum is the consideration for the actionable claim. For pending notices, this judgment gives the revenue a solid legal foundation to continue assessments. Taxpayers should review their positions for open periods accordingly. Thanks for watching this video. You can download the full analysis, case law, and case digest PDF from our website, taxpundit.org. Feel free to write to us or message us on WhatsApp at 932-630-6668 for any assistance. Don't forget to subscribe for more landmark updates.